Modern Real Estate Practice, page 103. Requirements for a valid deed. Although formal requirements vary, a valid deed generally must contain the following elements: grantor who has the legal competency to execute the deed. Grantee named with reasonable certainty to be identified. Statement of consideration, usually required for recording of the deed. Granting clause, words of conveyance. Habendum clause, which defines the ownership right received by the grantee. Accurate legal description of the property conveyed. Any relevant exemptions or reservations. Acknowledgement, notarization of the signature of the grantor. Delivery of the deed and acceptance by the grantee to pass title. A deed may include a description of any limitations on the conveyance of a full fee simple estate, and a statement of any exemptions and reservations, also known as subject to clauses, that affect title to the property. In practice, the deed to each property in a subdivision that is subject to covenants, conditions, and restrictions, CC&Rs, will include a reference to the recorded document that sets out all of the limitations on the property's use. Grantor. A grantor must be of lawful age, usually at least 18 years old. A deed executed by a minor is generally voidable. After reaching legal adult age, the minor can choose to treat the deed as a valid conveyance or can have the conveyance recognized as of no legal effect by a court. A grantor also must be legally competent, of sound mind. Generally, any grantor who can understand the action being undertaken is viewed as mentally capable of executing a valid deed. A deed executed by someone who was mentally impaired at the time is voidable, but it is not automatically void, of no legal effect. If, however, the grantor has been judged legally incompetent, the deed will be void. Real estate owned by someone who is legally incompetent can be conveyed only with a court's approval. The grantor's name must be spelled correctly and consistently throughout the deed. If the grantor's name has changed since the title was acquired, as when a person's name is changed following marriage, both names should be shown. For example, Mary Smith, formerly Mary Jones. Grantee. To be valid, a deed must name a grantee. The grantee must be specifically named so that the person to whom the property is being conveyed can be readily identified from the deed itself. In practice, Olive Burbank wanted to convey White Acre to her nephew, Joseph Mara. In the deed, Olive wrote the following words of conveyance: I, Olive Burbank, hereby convey to Joseph all my interest in White Acre. The only problem was that Olive also had a son named Joseph, a cousin Joseph, and a neighbor Joseph. the grantee's identity could not be discerned from the deed itself. Olive should have conveyed Whiteacre to my nephew Joseph Mara. If more than one grantee is involved, the granting clause should specify their individual rights in the property. For instance, the clause might state that the grantees